All right. All right, good morning. everybody.
Morning, Your Honor.
Good morning.
Good morning, Your Honor.
Okay, so this is in the matter of Troy. I'm going to mute the courtroom there. This is in the matter of Troy McLaughlin and Gail White. Well, Troy McLaughlin plaintiff and Gail White an individual, intervening plaintiff versus Stephen Barnstable an individual, Teebs LLC, a Michigan limited liability company doing business as Teebs of Adrian, and Barnstable Realty LLC, a Michigan limited liability corporation, file number 22-6888 CB. On that file, I have, let's see, make sure I have everybody here right. Will Furtado, P77848, appearing on behalf of the plaintiff. Jacob Carlton, appearing P84859, appearing on behalf of defendants. And Daniel Troika, P65155, appearing on behalf of intervening plaintiff. We also have, get these orders out of the way. It's one. All right, and Becky, I have no idea what I did with my docket. So, thought. Okay. So then we also have. No, I guess that's it. So for some reason, I thought I had another file. Is that right?
I believe you have another file if you're looking
Yep.
for the Jeffrey Adair file.
Versus Teebs LLC, file
Yes.
number 2023-237081 CB. I was looking at the
No, 23-7081 CZ.
CB. Yep.
CZ.
Z. There it is.
Z. Thank you.
All right, hold on one second hold on one second. Right, and that's okay. So then on 23-7081 CZ, there's a motion. And it's under file number 22-6888 CB 23. Okay, got it. All right. The headings and the file captions. All right. So I was a little lost on that. So I think, and then we have Diane Subley appearing on that file. And where you at? And it's P32005 appearing on behalf of, well, attorneys for a limited intervener Adair. All right. So counsel, it's all convoluted. So we've had fun with this because it's been a fun week. But I guess we could start with, which motion do you guys want to start with?
Your Honor, if I may, I think there's an objection to our proposed order on the 7-day rule.
Yes.
The relief we are seeking in that order is the same relief we're seeking in our motion. So frankly, I actually agree with Mr. Troika that the 7-day rule is probably not the best way to have presented that. What had happened, Your Honor, is in the Adair matter, I was ordered to present that order in the McLaughlin matter. I presented it. I received a note from the court rejecting the pleading and advising me to refile it under the 7-day rule. So I refiled it under the 7-day rule. I recognize that that's probably not the appropriate use of the 7-day rule. But so instead, I just filed a motion seeking that same relief. So I'm fine with the court sustaining Mr. Troika's objection to the use of the 7-day rule, and we can focus on the issue in my motion if that helps solve some of these cross motions here.
Yeah, Your Honor, I think that makes sense.
Okay, so I have a proposed order and I don't know who presented this. Order on defendant's 7-day presentment.
That was
Okay.
probably my proposal. I think we can just set all that aside and deal with the motions that have been filed and responses.
Okay. All right, so we'll just then proceed. Do you want to start with motion for entry of or to intervene for the limited purposes? Mr. Jeffrey Adair's motion first, or motion for payment of certain obligations from sale proceeds?
I'd appreciate at least knowing whether I can intervene for the limited purpose. So if the parties do not mind, I'd appreciate being able to go first, Your Honor, for as long as my voice holds out.
Any objection, Mr. Troika, Mr. Carlton, Mr. Furtado?
For what it's
Your Honor,
worth, go ahead, Dan.
Let's say I don't object to Ms. Hubley being heard today. I think logically, probably Jacob should go first because that's really the start of this. I'm not trying to tell anybody how to do it, but I think that that's just the logical order. And I think my objection is probably the logical second point. Obviously, I'll defer to whatever order the court wants.
Anybody else? Mr. Furtado, Mr. Carlton, weigh in?
I think that makes sense to me to go first. And for the record, I have no objection to Ms. Subley's request to, appear and engage in, limited intervening sense. But I think the presentation of my motion will answer a lot of these questions about the appropriateness of the intervener and everything else and everybody's objections to my motion.
All right, well, all right, so we'll start with your motion then, and your, that would be your motion for payment of certain obligations from sale proceeds.
Yes, thank you, Your Honor. What we're asking for, Your Honors, is pretty straightforward. We're asking to pay 4 things out of the funds that are received by Teebs through the asset sale. Those 4 things requesting to pay is Teebs's outstanding tax obligations, the judgment that Jeff Adair received in the other matter, the note that forms the basis of at least one count of Mr. Troika's complaint on behalf of Gail White, and the outstanding attorney fee obligations that my client owes to Miller Johnson. I will start with the taxes, Your Honor. Reading the pleadings, I'm not sure if anybody has fully objected to the taxes. I know there were some statements about that not being part of the original escrow order. MCL 450.4808 section 2 is clear that when an LLC is winding down and selling its assets, before anybody can get paid, taxes have to get paid. That's sales taxes, that's excise taxes, that's employee taxes. So I understand everybody wanting a piece of this pie, but before anybody can get it, taxes have to be paid off. And these taxes are accruing interest. They're incurring penalties for being not timely paid. And so our request, Your Honor, is simply to allow Teebs from the proceeds of its asset sale to pay off all of its tax obligations. This will stop the interest accruing. This will stop the penalties accruing, and it'll solve the state of Michigan's what's owed by Teebs to the state of Michigan and what's owed to its federal employee taxes. Again, all of these would have to be paid before anybody else can get paid. Taxes have a complete priority over any creditor, over any member. Taxman always gets paid first. So that's what I would have to say on part of the taxes. As far as the fees of Miller Johnson, these are fees Miller Johnson has incurred in defending this lawsuit brought by Troy McLaughlin, the intervening lawsuit brought by Gail White, the lawsuit brought by Jeff Adair, and also ordering and structuring the asset purchase agreement that sold Teebs and the real estate purchase agreement that sold the assets of Barnstable Realty LLC. These are fees my client owes me. These are, as an attorney, since we have facilitated the sale of the transaction, the law allows us to file an attorney's lien on the proceeds of that sale for the amounts that are owed to my law firm. So the attorney fees owed to Miller Johnson by Teebs and by Barnstable Realty LLC would have also had priority over any other creditor on the basis of an attorney's lien, which is why we're requesting that those get paid. The judgment of Jeff Adair, in my view, is pretty straightforward. The court has ordered judgment. The court has ordered judgment that Teebs pay that amount to Mr. Adair. So we're requesting permission to pay that. On the note of Gail White, Gail White has a $50,000 note that she invested into Teebs. We're requesting that the court allow us to pay that note off in full, with all interest included, and that total is $68,333. Now, Mr. Troika has lobbed an objection onto that amount on the basis that it's not equal to exactly half of the amount of Mr. Adair. Mr. Adair invested $100,000 into the company. The difference in his judgment is in the amount of $146,410. And, you know, the amount owed to Ms. White is $68,000. So while it's not quite doubled, it's pretty close. And the discrepancy there, Your Honor, is simply an interest calculation. Mr. Adair's note was larger and it was paid earlier than Ms. White's note. It incurred interest at a higher rate on the basis that there's a larger principal. So this is not us favoring one creditor over the other. It's just a simple calculation of interest. Gail's White note to date, if paid in full, would be owed $68,333. That was actually at the time we filed this motion. I'm not sure if the interest is slightly different today. It might be. But that is, as of the day I filed the motion, the interest owed on Gail White's $50,000 note. I know Mr. Troika has an objection arguing as well that his client invested more money into Teebs. And Your Honor, frankly, from our position, that's just not true. If he can present any evidence to the court that Gail White put more money into Teebs LLC, I'm happy to entertain that. But he cannot today present any evidence whatsoever that Gail White put additional funds into Teebs LLC. The funds that Mr. Troika are talking about was an investment into Barnstable Realty, not Teebs LLC. And so there's no basis to hold up the payment of all of these outstanding obligations on the argument that Ms. White has invested additional funds into Teebs LLC when they have no evidence that those funds were invested. As to the objections of Mr. Furtado on behalf of his client, Troy McLaughlin, Troy McLaughlin did not invest and does not have a note owed by Teebs LLC. He is not a member of Teebs LLC, as this court has already ruled. His argument in his case is that he should have been an owner. That's the entire basis of Mr. McLaughlin's complaint against Teebs LLC.
You said he should have been an owner?
Yes.
Yeah, thank you.
Yes. So Mr. McLaughlin's argument is that he should be a 50% owner of Teebs LLC. All of these obligations that we're requesting to get paid would have to get paid before any ownership distribution would be made to Mr. McLaughlin. They would all have to be paid before any ownership interest is paid to my client, Mr. Barnstable. And I would also like to point out, Your Honor, that my client, Mr. Barnstable, also has a $35,000 note invested into Teebs LLC. We are not at this point requesting that the court allow Teebs to pay Mr. Barnstable. While I think we would have merits to this position, I understand the objections that would be lodged of us requesting to do so. We are not requesting payment on that note. We are simply requesting that the court authorize us to pay the amounts that are clearly and unambiguously owed by Teebs LLC.
Okay. Anything else?
Unless the court has questions, I'm sure everybody else has lots they would like to say.
So I just want to clarify one thing, and I think I'm correct from reviewing everything. So the assets of Teebs have been sold, correct?
They not yet.
Not yet?
There is a purchase agreement that's set to close soon. There's lots
Okay,
that are being worked out. This motion is one of them to make sure we have authorizations to pay the taxes. Is something the closing company wants to see, that we have approval to pay the sales taxes before closing.
okay. And the realty and the building were owned by Barnstable, correct?
The real estate was owned by Barnstable Realty LLC. That's a separate real estate purchase agreement. So there's two purchase agreements. There's an asset purchase agreement of Teebs LLC that's purchasing all assets of LLC for some certain. There is a real estate purchase agreement from the same buyer, actually, I think it's technically a separate buyer, but the same overall principle of purchasing the real estate assets of Barnstable Realty LLC. The funding on the real estate purchase agreement is a note secured by a mortgage. So the asset sale of Teebs, all the cash is going to come in at one time. The real estate funding is going to trickle in over the next 3 years after closing.
Hold on one second. Mr. Love, I know you're in the courtroom, and I just instructed my staff that if Ms. Underwood wants an adjournment for a couple weeks, we'll go ahead and grant that, okay? So thank you, Mr. Love. All right, so Mr. Treka?
Thank you, Your Honor. I appreciate Your Honor's time. I know this is confusing. Our primary objection is really the timing of trying to do this essentially on an emergency basis for an insolvent company. So I want the court to understand what is literally being proposed. The sale of Teebs, the operating company, is for $500,000. That's the contract. If you take the numbers in Mr. Carlton's motion and add them up, and I'm including only payments on behalf of Teebs, not Barnstable, is $443,992.93. So when you consider transactional costs, commissions, what have you, and in particular, when you consider rent owed by Teebs to Barnstable Realty, which I'm told is about $90,000, the company is insolvent, even if you don't consider my client's extra $150,000 claim. So if the court grants this relief, certain people, for example, Jeff Adair, is going to get 100 cents on the dollar for his claim, and other creditors, including creditors not in dispute, will have to take a discount because there's not enough money to cover everybody. This really should be in bankruptcy, but it can't because it's cannabis. Should be in receivership, but I understand that Mr. Furtado asked for it, and for what it's worth, well, I think that makes sense. It's way too expensive. I hate to see this company bled more, but it should be in some form of insolvency proceeding. And what you don't do with an insolvent company is come and say, okay, I'm going to give you all this money up front, and then I'm going to let the remaining admitted creditors fight for whatever's left and take a discount. I believe the whole point of Your Honor's order back in March requiring proceeds to go into escrow was to allow for an equitable distribution to creditors. So that requires a means for determining what the creditors are owed. And it will require in this case that there be some discount for legitimate claims because the company, according to its admitted debts, can't pay everybody 100 cents on the dollar. So this is not really a motion for interim relief. It's a motion effectively for final relief, and that is unfair to my client. I will note discovery is still open. It's open to November 3rd. I am promised documents from Mr. Carlton tomorrow, which will enlighten me on what's going on. My client's being deposed on November 3rd, asking for what is in effect final relief today against an insolvent company is improper. I do want to note that my client is not objecting to those things that need to happen in order to facilitate sale. So I will take Mr. Carlton at his word with his representations about what is owed in sales and excise tax and the employer and employee tax. And if those are requirements of closing, we're not going to object. I understand a buyer needs it free and clear. We're not trying to get in the way of what appears to be, the best deal we can get. So we would sign up for that with the caveat that if it turned out there was some misrepresentation, we might have a claim back against Mr. Barnstable, but I'm not alleging that at the moment. I will note that Ms. Subley has said that Barnstable basically improperly took a large salary while not paying these taxes. I do think that's something that might get litigated later. But I agree with Mr. Carlton. We got to let the closing happen. I don't think the court should do anything that would close it up, because that would take a bad situation and make it worse. If the court is going to allow distributions to the parties and counsel, despite the fact the company is insolvent, they're simply wrong in the calculation of Ms. White's note. And Your Honor, you can do this. It takes about 30 seconds.
Hold on 1 second. Hold on. Jeff, you got to leave the courtroom open still. Thanks. Okay, go ahead.
If you look at Ms. White's note, which is identical to the Adair note, except that his is 100, ours is 50, 10%, it starts in September of 2019. You multiply that, you put the 10% interest on each year. On September 1st, 2023, simple calculation, she's entitled to $73,205. So, and Your Honor, to be clear, this is how you compute these notes: 50,000 times 10%. Then you take that, you compound annually another 10%, and that happens 4 times, and that gets you to exactly 73,205, which is exactly half of what Adair is getting. So, if the honor is going to allow distributions from an insolvent company that has the effect of stiffing other legitimate creditors, we should at least get what we're owed, which is 73,205, and it would be very unfair for Your Honor to effectively grant summary disposition on our claim and take a $5,000 haircut when this hasn't even been litigated and discovery is still open. I'm not seeing any harm in Mr. Adair, my client, basically waiting to let things shake out. And if we have to take a pro rata discount, so be it. There's been a suggestion by Ms. Subley and Mr. Carlton that my client is playing fast and loose and making inaccurate representation to the court. I don't want to go into great detail here, because this is effectively, again, asking for dispositive relief when discovery is still open. But I want Your Honor to understand what happened. My client, Gail White, very unsophisticated. She was best friends with the wife of Stephen Barnstable, and they're now divorced or getting divorced. Best friends with her since grade school. She's the one who got her to invest in this business. She gave $300,000 cash. Nobody disputes that she put in $300,000. When you look at the documents, no one disputes that there's a $50,000 note that is signed. No one disputes that there's a $50,000 capital contribution for a second 10% interest in Barnstable Realty. Beyond that, the remaining $200,000 is not documented in the form of an agreement signed by both parties. Now, Ms. Hubley points out there are other documents which may be relevant, and there are tons of them. The reality is that Mr. Barnstable made all sorts of representations to Ms. White, which she relied upon, gave her all sorts of documents that she suggested one financial arrangement or another. I'm not alleging that those were signed, they were not, but the issue is if she threw an extra $150,000 into these businesses, what is it for? If you listen to Mr. Barnstable, he is actually saying there is no way she could ever have gotten credit for it. We don't believe that's true. We have a lot of evidence, including some third-party evidence who can testify as to what Mr. Barnstable said about Gail, which we think would persuade a fact finder that she is owed at least an unjust enrichment for that extra $150,000. And I want to address specifically the claim that there's a fraud on the court with regard to the IRA lending. So I'll tell Your Honor what happened. And as far as I know, this is generally understood. So I agree I didn't explain it to Your Honor because I'm respectful of your time and I don't think it needs to get into now. But since it has been flagged, when
I have
Mr.
all day today, Mr. Troika. You're my last hearing, so
That's what I thought, Your Honor. I can make it last all day too, if you'd like. So I won't be long on it, but there were all sorts of discussions between Barnstable and White, and these they're documentation, things change back and forth. Those probably aren't enforceable contracts, and I'm not purporting to say that an unsigned document is necessarily an enforceable contract, although it can be, but that's not my point. Ms. White didn't have a lot of money, so Mr. Barnstable made a play for her retirement money. It's part of what makes this case so tragic for Ms. White is she's essentially, rightly or wrongly lost pretty much all her money to Mr. Barnstable. She did take $190,000 out of her IRA. And in the documentation, it's noted that this is going to Barnstable Realty because that's what Mr. Barnstable told her to do. But at the same time, he gave her that $50,000 note, which we all agree is valid based on the money coming from her IRA. And that's what he told her he was doing, that she would put the money, she would direct it to Barnstable Realty LLC. It was $190,000, and that he would give her, a note, a convertible note in Teebs. And she actually got the $50,000 convertible note from Teebs at that time. And then she later put in another $60,000 to Teebs. So even if you accept the theory that by giving money out of her IRA, she essentially just gave it away, which I think is not a good argument, but even if you accept it, because that's what effectively Mr. Carlton and Ms. Hubley are saying, she still put 110 into this company, which is documented. The second 60,000, when I say it's documented, is not, there's no note, but there's a transfer that shows that she transferred it to Teebs directly. So we would take the position that, you got to pay it back in some fashion. I think this is way too complicated to expect the court to rule on this today when discovery is open, but you are effectively being asked by Mr. Carlton and Ms. Hubley to rule against my client, tell her she's entitled to nothing for that extra 150 that nobody can explain, and be left with the claim against a company that will have zero assets if you approve this order. So what I propose to the court is that we allow disbursements from escrow of what is necessary for closing, and we then have a subsequent claims procedure in which the court can decide what claims are legitimate, and if there has to be a discount, so be it. We are not, by the way, objecting to the amount of Mr. Adair's judgment. It seems to be right to me. I did the calculation for him. I did the calculation for Ms. White. She should be exactly half, but we're not here to say it's a bad judgment. What I am here to say is that there's no basis for preferential treatment to give him 100 cents in the dollars and then say other people have to take a discount. And I want to be particular. My client owns 20% of Barnstable Realty. That's not disputed. That means the money owed by Teebs to Barnstable Realty is effectively 20% my client's money. That's not accounted for. This request to pay omits that, and there's not enough money for it. So there's going to have to be a haircut, even if you accept everything said by opposing counsel is true, and therefore nobody should be getting 100 cents, which again, I think is what the court intended with that escrow order. What we need is a final order after the sale closes, not an interim order that prefers certain creditors. Thank you.
all right. Who'd like to go next?
Yes, Your Honor. I'll try to be short and direct. I concur, and the plaintiff concurs in much of what intervening plaintiff White has argued. A couple things just straight off the bat in terms of relief and release of any funds from escrow. Plaintiff McLaughlin is not going to object to release of sales, excise, and employment taxes necessary to complete the sale, so long as they're sales, excise, or employment taxes, not personal income taxes, not corporate income taxes, things like that. So just want to kind of get that out the gate immediately. There's a couple things to discuss here, in no particular order, really. I don't represent Gail White, but I do think it is necessary to correct the record before the court based on what Mr. Carlton has represented here, which is that there is no evidence at all that Gail White invested more than $50,000 in the company. That is absolutely not the evidence. Mr. McLaughlin's deposition was last Monday. He testified in no uncertain terms that Stephen Barnstable.
Mr.
told him-
Furtado, so you're back far enough from your microphone that when you move your head, you pop in and out. So if you could just scoot up a little bit. Thank you.
Can you hear me?
A little bit. Try say it again.
Can you hear me, Your Honor? I do apologize.
That's better. That's better.
I feel very odd that I'm this close to the camera now. But
Well, you can back up a little bit. You were just too far away earlier. Okay.
Can you hear me, Your Honor?
Yes.
The testimony from Mr. McLaughlin at his deposition 2 weeks ago, less than 2 weeks ago, was that Stephen Barnstable told him Gail White invested $300,000 in the business. This representation by Mr. Carlton, there simply is no evidence beyond the $50,000 is not true. What Mr. Carlton wants is exactly what Mr. Troika has characterized that. He wants a dispositive motion ruling here. He wants to say there is no question of fact about the amounts owed. We're going to win this case. You should just go ahead and distribute these funds. But this is exactly what was discussed by this court almost a year ago in January, when plaintiff McLaughlin filed a motion for preliminary injunction and this escrow order was entered. Can you hear me, Your Honor?
You're kind of muffled. I think it's your microphone. I don't know. But anyway, keep going. I can hear you.
Okay. The idea of paying note creditors from the escrowed funds was raised by defendants during the January hearing. It was put in their proposed escrow order in February, and it was denied by this court. The idea that note creditors should get paid on a priority basis while the value and amount of those notes is being litigated is absolutely improper. That was the point of the escrow order. And for Mr. Carlton and Mr. Adair to collude to make an end run around that escrow order is entirely improper. Mr. McLaughlin filed this lawsuit a year and a half ago to protect his interests. Mrs. White intervened in this case to protect her interest. An escrow order was entered to protect their interests. After that escrow order was entered, then Mr. Adair decided he wanted to file a separate lawsuit, get a stipulated judgment from his friend Stephen Barnstable, and take that judgment to this court. That is an end run around the escrow order. It is improper. It should not be paid. Same with the attorney's fees. There is nothing in the escrow order that allows for the payment of attorney's fees. Nothing. Those attorney's fees have been requested have not been established. They've sent blank invoices with no description at all of the services provided and that identify Stephen Barnstable as the client, not Teebs, not Barnstable Realty. Even Diane Subley and Jeff Adair have objected the payment of those attorney's fees for that exact reason. Mr. Carlton didn't even bother to respond to that other than to say, well, I'm owed money, I should be paid. Well, you know what? Join the club for attorneys in this litigation. With respect to the claims that Mr. McLaughlin has asserted, correct. His primary theory in this case is that he was told he was going to be a 50% member in the company. And the remaining claims are promissory estoppel on that promise, equitable partnership based on those promises, and then in the alternative, there is an unjust enrichment claim for the value of the services that Mr. McLaughlin provided to the business for a year and a half. That is not based on an ownership position, an equity position, a distribution of equity assets. It's based on the reasonable value of those services. And it's akin to an employment claim, an employment wage claim. And the idea that, creditors should get paid before frontline service people, frontline employees is absolutely improper. And Jacob Carlton and Stephen Barnstable have attempted to ignore those claims, ignore the evidence, ignore this court's prior rulings. They want, let's look at the fact they want relief from an escrow order that they haven't complied with yet. There's no evidence that any funds have been deposited into escrow as required by the escrow order. And the escrow order doesn't allow defendants to pay these amounts. The escrow order requires the funds to go into escrow, and then the escrow company can pay these amounts out. There's been no closing statement provided. We've been asking for months for information about this sale. What are the amounts owed? Who are the creditors? What are the transaction costs? What are the broker's fees? What taxes are owed? None of that has been provided. There is no information at all about these closing costs other than a statement on paper that they're owed and a collusive stipulated judgment between Adair and Stephen Barnstable. Any payment of creditor amounts at this time is improper. We do not object to the payment of the amounts needed to close the sale. That was the point of the escrow order. But the idea that Mr. Adair or Gail White or any other creditor can just come in and get a priority payment is absolutely contrary to the way this should go. It's contrary to the escrow order. It's contrary to equity. I think that is all I have, Your Honor. Thank you.
Okay. Anyone else?
Yes, if you would entertain me speaking for just a moment.
Sure.
The one thing that I have been attempting to indicate to the court is that there is an important fact that can be resolved by documentation. Ms. White has claimed that she's confused about whether her 190 or 200,000 is a loan to Teebs or was a capital contribution. And I understand now that the deposition of Ms. White will be taken and that discovery will close on the 9th. Because she has, her counsel this morning has indicated that the funds came from the IRA, it makes the argument that I've made in my separate motion attempting to show the court that we do need documents from Ms. White, and the documents that she could provide would be the documents that show that the capital contribution of $50,000, which she claims she made, came from her IRA. Because my understanding, and I know you probably have not read my CV in the other matter, which is submitted in terms to prove our attorney's fees, which we all understand may be difficult for all of us, shows that I was a senior vice president and deputy general counsel of a global bank. I'm used to working with special assets and with what banks have to retain. So it is my position that if Ms. White does not have documentation showing that that the 150 that was claimed in the objections is a capital contribution, she should produce the documents that show what her 50,000 was characterized as by the IRA custodian. My belief is that it will be the IRA custodian would not allow it to come to be booked against or provided to Teebs. That is because of the Schedule 1 Control Substances Act, in which cannabis is still an illegal substance. And therefore, the custodian would have said, you need to fill in the private equity authorization form. That would show it going to Barnstable Realty, and it would show the first 10%. There should be a similar documentation for the large, what she is trying to characterize as she's confused about, which was a purported loan to Teebs, which cannot occur because the banks will not do that. And that is why I suggest that we have an order entered for those documents that would resolve that factual question. I did some research on, I looked through the general ledger that I could see. There was a transfer back in the general ledger of 10,000 to show her 200,000 in Barnstable Realty, and I can give you the item number for that. But more importantly, the so-called 190 is shown as coming from Pensco.
I'm
This
sorry.
would touch your honor. Yeah, is showing us coming from Pensco, which was the former name for Pacific Premier Trust, which is a division of Pacific Premier Bank. And that bank is regulated both by the California Division of Financial Transactions and by the Federal Reserve. There is a 5-year document retention requirement. If this goes on much longer, and the court has warned us in pretrial conference that we're not likely to see a final proceeding in even 2004 or 2005, we will be beyond that document retention requirement of that bank. So if Ms. White has lost or misplaced her documents, then the source would be the bank, and we would be outside the source, the time period for document retention. That's why it's important to get those documents so that we know that the only convertible promissory note that Ms. White should be paid at whatever interest rate it should be, which is 10%. And Mr. Carlton was saying that she was paid at the appropriate, at a different rate. He meant in a different amount at the same 10% rate compounded. And whether Mr. Troika's figure is correct or Mr. Carlton's figure is correct can be sorted out by the court, but there's only that should be attributed to Teebs. The rest of the money is invested as in Barnstable Realty, and that is what those documents will show. And they need to be presented to the court now so that we're not waiting for a final trial. That's something that is external to anything any of the lawyers in this case would have done. It's a decision made by the financial institution that funds from an IRA, which is what Mr. Troika said they were, cannot be invested under the bank's procedures because the area is so gray, the banks don't allow it in Teebs. They must be capital contributions to Barnstable Realty. So that is one purpose of my intervention. The rent, as I understood it from Mr. Carlton, was less, but I don't have an exact amount because no one is asking on paper for an exact amount as yet. I thought it was somewhere near 62,000. Now I hear from Mr. Troika that he thinks it's 90,000. It is part of the money owed by Teebs to Barnstable Realty that will assist in the trickling out of 36 months of payments for which both Gail White and my client are entitled to 20%. So I am very concerned that we at least get that fact question resolved. And I think that, number one, Mr. Troika could have come in and asked for the same enforcement of the note that I did in the separate matter for Gail to get his 50%, and he would have perfected that. So that his delay in producing the documents or even asking the bank, which he could have done with his client for proof, suggests that the proof would show that they are really capital contributions, that 150,000, and not a loan. And I think we cannot afford to wait until a final distribution order. So with my background, I consulted with Max Newman of our firm, who's both a bankruptcy lawyer and a collections attorney of some note. And he is the one who said an interim distribution order would make sense in this case. And you should make sure that there is some mechanism in place to get those records from the bank if Ms. White claims they're lost or misplaced. That's the first argument, and I think the most important. This court can resolve that factual question without waiting for a trial in 2025. Second, the notes, and I would turn the court's attention to exhibits 4 and 5 that we submitted under seal with Mr. Adair's affidavit, and they show exactly what I'm saying about the private equity authorization, that it goes to Barnstable Realty and in what percentage of ownership. So you should look at those, and I'm certainly willing to provide them to other counsel as long as they are submitted under seal, because they have redacted bank information and redacted information that is redacted because of the court rule. So that there is the example of that kind of form that I am asking that Mr. Troika and Gail White get from the bank if she has somehow lost it, because it's his burden of proof to show that he has a creditor loan of $150,000. And in this case, in this industry, he will not be able to show that funds from an IRA were promised. He should have a file that shows they were denied from the bank and that the bank would only loan to Barnstable Realty. And that makes Gail a 20% member and entitled to 20% of what comes in over the 36 months for Barnstable Realty, but she is not a creditor on a loan. And that is what those documents will make clear. Second, Mr. Troika's own documents show that even if they were not enforced, that the convertible promissory notes to any payer would have to be the same. And I will note that there's a materiality date in that document that he has provided. He relies upon the convertible promissory note, which is unsigned, and in Exhibit 1. But when you look at the promissory notes of Adair and White, what you see is a contract not capable of being performed within 1 year. The date of the note is in September 1 of 2019. The payments of each note are not to be made under paragraph 2 until 2022. It is not capable of being performed within 1 year and therefore is not enforceable under MCL 566.1321A, as I briefed. Given the affidavit of Ms. White, who says she's very confused and thinks the money should not be a gift, and Mr. Carlton and I are not saying it's a gift, we are saying it belongs in Barnstable Realty. So I would appreciate the court understanding our true position and not how it's been mischaracterized. If it is indeed so much confusion, then I've cited to the court the decision that says there is no mutuality of assent, and therefore that cannot be enforced. So I would encourage the court to not enforce that purported loan obligation because it's outside of the statute of frauds and outside of mutuality of consent based on Mr. Troika's own exhibits. As to the sales and excise taxes and the taxes that are owed, I agree with Mr. Furtado and Mr. Troika that if they are only the sales and excise taxes and only the owed employment taxes, they will need to be paid in order to close so that there are some funds available. But I also want a reservation on Mr. Barnstable's $35,000 should not be paid, which he is not asking for at this time, because he would have should have been paying those sales and excise taxes all along. So in an equitable sense, what I am saying is, yes, we need to pay them for closing. All of us recognize that we do, but remember that this gentleman took $190,000 in salary instead of paying those taxes, and that he has a note that he's reserving, asking for payment on against Teebs at this time. So I would suggest that the rents be paid over if they can be, because that is a debt owing from Teebs to Barnstable Realty, and it is provided for in this court's March 2nd and 3rd 2023 orders. Rent is, attorney's fees are not. Finally, I'd ask you to deny all of Mr. Troika's objections. There's a reason, because of the how shall we say, fireworks or sort of scorched earth work that's being done in this case, that Mr. Adair wanted to file separately to be cleaner about his creditor loan and to indicate his true amount that was invested in Barnstable Realty, which he realizes he has to wait for over 3 years and get the proceeds as provided. So that we don't want to consolidate, we want to stay separate, but intervene for this limited purpose. So those objections should be denied. As to attorney's fees, I agree with Mr. Troika and Mr. Furtado. They are absolutely not allocated at all. So we don't know how much should be taken other than from assertions in a brief or an oral argument against Teagues, and how much should be booked against Barnstable Realty. There are representations in the brief that we still do not have all the fees for the real estate transaction in Mr. Carlton's brief from his colleague, Ryan McCarthy. And so I think the court should not approve. They are certainly not secured liens at this time that stand in a priority to the rest of any judgment creditors. They need to be fleshed out in the same way that the court asked that we have a procedure in our separate proceeding to show what those fees are, where they were allocated between the two companies, and to allow us to file objections and Mr. Carlton to file a response. So that is why we are asking that the fees be denied at this time. Is there any question that you might have? I do want the IDO entered, even if, the interim distribution order, and you can understand my concern about waiting for a trial in 2025 for some kind of final distribution order, given what the court has said about the backlog of criminal cases that need to come first and the predicted trial date.
We're actually, none of them actually go. So I think they just were all delaying jail time. But, we had like 3 scheduled this week and they all went away. I had a 17 civil trial that was supposed to be at the end of the month, and that settled yesterday. So everybody's settling. So
you're moving
may
your
be
docket
able to
along. Nonetheless, the
Yeah.
simple fact that has been what I feel is a misrepresentation to the court is that there is confusion about whether there is a loan or a capital contribution on Ms. White's part. And there has been resistance to get the documents either produced from Ms. White by Mr. Troika and Ms. White or gotten from the bank. He could have gotten those documents early on, and not getting them allows this so-called confusion to continue. It reminds me of a case that I had in federal court some years ago. The only other instance where I've ever made a statement like I made in the briefs about misrepresenting to the court. And that was where a divorced wife attempted to claim she was still married. The insurance proceeds had been paid by the HR director before he got my advice to just do interpleader to the son. And all the way through the litigation, there was resistance to getting the Social Security records. When they were finally gotten, it showed that she stated to Social Security that she was divorced while stating to the court that she was married. That's the kind of confusion that was maintained in that court for a long period of time. And I want to avoid it here because it really does hurt my client. And it shows that Mr. Carlton and I are not in collusion. We are attempting to get an actual judgment creditor in the actual promissory note loan amount that is factual paid. Ms. White is trying to take $200,000 and push another $150,000 back into Teagues so that she will be paid as a judgment creditor on a misrepresented fact that could clearly be cleared up before November 3rd in time for her deposition with an order of the court.
Are you asking for an order to
Yes.
get the documents from the IRA custodian?
And for Ms. White, I want a representation that she's either lost them or can't find them. And yes, an order asking that we get, and we can identify, I'm telling you as a bank lawyer, knowing the approximate date from the general ledger, we should be able to know from Ms. White when she approached the the IRA custodian, it's either in the amount of 190 or 200,000 that she's trying from her retirement money. And whether it's an IRA or a 401k, that same prohibition that banks follow because of this gray area of taking that money and giving it to a cannabis dispensary because of Schedule 1 would be rejected by that custodian, and she would be told she needed to invest that money in Barnstable Realty. You can clear that fact up. Yes.
So, Your Honor, may I respond?
Sure.
So, Your Honor, this is a rather bizarre situation. It's basically a drive-by dispositive motion. This motion was filed on Friday of last week, or I received it on Friday of last week. And Ms. Hubley is essentially asking for final relief, also asking for an order to compel where a request has not been made. So I don't think that's at all appropriate. In fact, I take great exception to acting like we withheld something because we weren't asked for it. I want to tell the court on April 5th, I wrote Ms. Hubley. I said, hey, we need to talk. If she had bothered to respond, we would have talked. If she thought that she needed something from us, I'd have looked for it and gotten it. Anybody in this case, whether they like me or not, would tell you I'm very cooperative. I don't play games. If I had known this was some big issue that was going to be put forward to the court and be told that this is only the second time in this person's storied career that she's dealt with fraud of this magnitude, yeah, I would have dealt with it proactively. But what happened is I got zero response to my April email. The first I hear from Ms. Hubley is what I get on Friday, which is a request for dispositive relief against my client, and now a demand that she be ordered to produce something as if she'd already been asked. I think there is a right way to deal with this, and my proposal to Your Honor is that the cases be fully consolidated. I just listened to Ms. Hubley tell me things I never knew. I just heard about a ledger, which supposedly says something about my client's interest in Barnstable Realty. I just heard about affidavits filed under seal by Jeff Adair. I just heard he's looking for more money. I mean, where's that money going to come from? It's going to come from the escrow under this court's control in this case. The whole idea of continuing to litigate in a separate courtroom and make all these secret claims that aren't shared and then come back and expect to be paid without any objection just is not how you deal with an insolvent company. So they need to be consolidated. I am open to extending the current discovery deadline with regard to Ms. Hubley so she can make that request and I can do what I need to do to find whatever is out there. And I want to be able to make that same request to Mr. Adair to get whatever he has. So everything is open, but there's a right way and a wrong way to do it. And I do want to address, Ms. Hubley is sitting here saying she's essentially playing the authority card that she knows because she's been essentially an attorney compliance officer in an international bank, if I heard that correctly. And I want you to know, Your Honor, I do believe her. I honestly believe her. And I also honestly believe you need that kind of experience to understand what's going on here. I admit, I don't have it. And I know Ms. White doesn't have it, but I want to tell you what happened because I have seen some documents. It's not complete because nobody ever asked in the way Ms. Hubley has just asked. Ms. White did. Ms. Hubley's first of all correct that they told her, really Stephen Barnstable told Ms. White, no, you got to send the money to Barnstable Realty. You can't send it to Teebs because it's cannabis. So she directed $190,000 of her IRA to Barnstable Realty LLC because that's what Stephen Barnstable told her to do. He gave her a $50,000 convertible note from Teebs because he said it was okay to do it this way. Now, maybe it's not. Based on what Ms. Hubley's telling me, probably shouldn't have done it that way, but Ms. White just did what she was told to do. That $50,000 note, which we all agree is good, was funded from the IRA. I'm hearing it shouldn't have been done that way, but it was. Ms. White later gave $60,000, not from an IRA, to Teebs directly. That was $60,000. Well, there's nothing saying what it was for. I mean, that's the problem here. There's nothing, and then there's everything. You've got a huge paper trail in which there are all these discussions going back and forth, all these documents exchanged. I acknowledge that it's a mess, but this is not something the court can resolve at the moment. It's not something where the court in equity and justice can punish my client for not having provided something that wasn't requested or enter what amounts to final relief against her and foreclose her claim and tell her that, in fact, she's just a dummy and she parted with $150,000 accidentally, which is really what they're saying. And I want you to understand, they are saying that for the first 10% of Barnstable Realty, she paid $200,000. And then for the second 10% of Barnstable Realty, she paid $50,000. We all know that Barnstable Realty is worth about $450,000 because that's the purchase price coming up. So 10% is worth $45,000. They say that she paid $200,000 for a 10% interest worth $45,000, and therefore she's just a dummy and she overpaid by $150,000. That might be true. Your Honor might rule that way after a hearing or after motions. She certainly didn't understand she was making this enormous gift of her retirement money, for which there was no possible mechanism of ever recovering. She didn't understand that. Court may say, okay, you know, she is a dummy and she's got to pay for it. But there is a lot of evidence in Ms. White's favor. That's why we have trials. That's why we have dispositive motion practice. That's why we have fact finders. That's why we have judges to rule on the law. But you can't do it today, like 4 business days after I first heard all this stuff. You know, I'm aware these issues out there, so I don't want to be accused again of fraud, but I'm aware of about 10, 15, 20, 30 issues out there. I didn't know that Ms. Subley was going to come in and act like this as a fraud on the court and unethical behavior by me, because it's not. If there's anything you want me to tell you, Your Honor, I will tell you honestly. I cannot believe anybody, including Mr. Carlton or Mr. Furtado, who's worked with me, is going to say I would deliberately come into court and lie about something. It's just, I'll make mistakes. I understand that. I may have made a mistake here, but this is legitimately a situation in which she was told by Mr. Barnstable to go about it a certain way, that she would have what she says was, a promise of full repayment. She thought a convertible note from Teebs to represent what she was putting in. Should she have done it? No, she should have talked to an attorney. But I don't think you can take this set of facts and just say, oh, there's no question she just gave up $150,000 for no good reason, and therefore she lost, most of her retirement money. So my request, Your Honor, is that you deny that request. I'm happy to accept a document request from Ms. Subley. I want to be able to extend one to her as well. I'd like to see these affidavits, which purport to determine my client's interest against this company, at least indirectly, because the more Mr. Adair gets, the less my client gets. I want to see that stuff too, and it should be consolidated. I can't imagine anything more unjust or inefficient than having Jeff Adair litigate all these additional claims involving Barnstable and Teebs while we sit over here where the money is, not knowing what's happening in the other case. Ms. Subley says I'm supposed to follow it. I know it should be consolidated with our case. That's how you deal with it. How am I supposed to follow it? I mean, do I have to drive to Adrian on a daily basis and check what's in the court file? I don't think that's reasonable. So I ask that the cases be consolidated. Glad to work with Ms. Subley on a document request. I do have some of the information because when I found out what an issue this is, I got what I could. But it is true that Ms. White is disorganized. She doesn't understand things. I certainly haven't done the due diligence I would need to do to be sure I have everything. I suspect there are things I haven't seen, and that's just life, especially with a client who truly doesn't understand any of this.
May I respond a moment, Your Honor?
Actually,
First
I'm
of
going to
all-
pause for just a moment, so I'll be right
Sure,
back.
of course.
Okay, go ahead, Miss Sibley.
Thank you, Your Honor. First, let me just remind Your Honor of one thing that I neglected to indicate about Mr. Furtado's argument. Your Honor has already ruled that he is not a member of the company. And Mr. Furtado is trying for partnership, some kind of partnership, which is and equitable claims. So he is not someone who can object to judgment creditors at this point. Second, the ledger on which this is not a drive-by summary judgment motion. The ledger I was referring to was a deposition exhibit. In the deposition in June of 2010, Mr. Troika could have read through. That was one of 2 pages that actually came through as readable. You will recall we've had some problem in the other case getting readable Excel sheets. But the ledger came through, and all of that documentation in the ledger that I've referenced is true. We are not attempting then to wait for the trial, which, as I can tell from Mr. Furtado's remarks, will be a long time. I don't need additional discovery in this case. If this court wishes to just ask for it from the custodian, that would be great. Mr. Troika could have asked for it based on the affidavit. Oh, I did try, by the way, I did try calling your firm, Dan, and asking you to call me, and I got no response. And then I also read the affidavit at the time that was with the unsigned documents, just so you know, Miss White's 1222 affidavit, and I realized she was saying that she didn't know what she had contributed, whether it was a loan. She was confused, and she relied on the statements that, you know, it wasn't a gift and that it would be repaid. But I did try, and so I think we missed communication, but you still had the ledger at the time of the deposition, so you could have looked at that. And Mr. Troika's claim on behalf and
Okay, so
Miss White's claim.
Everybody stop for a minute, because we're going pretty south. I don't think I need anything else from you, Ms. Sibley. Mr. Carlton, any response to all of this?
Yeah, just, and I'll keep it brief, Your Honor. It sounds like, and hopefully I heard this right, nobody's objecting to taxes.
As long as, yes, with Mr. Furtado's.
Yes, and so if you review, Your Honor, the provision we have in our proposed order, the provision.
I have a proposed order that lists 6 items, correct?
Yeah, so if you review paragraph 3
and 4.
Paragraph 3 states, and I'll just read it for the record, is the escrow agent shall pay the state of Michigan $166,226 or any amount stated by any Michigan taxing authority from the proceeds of the sale of assets of Teebs LLC upon closing. I hope that is satisfactory to everybody, because that, I mean, that's all we're asking to do. We're asking the escrow agent to have the authority to pay the state of Michigan with the state of Michigan claims we owe. Section 4 is similar. The escrow agent shall pay the appropriate taxing authority all outstanding employee and employer tax obligations. That's, again, the amounts we're requesting for. There's certain of the last payroll that we couldn't afford to pay the employee taxes on. We're requesting that. So it sounds like nobody's objecting to that. So I would appreciate if the court authorized paragraphs 3 and paragraphs 4. Speaking briefly about Mr. Adair, you know, there's some allegations getting thrown out there that I'm colluding with Ms. Sibley. There's allegations that my client's colluding with Mr. Adair. That's simply not the case. The lawsuit presented in the separate matter is straightforward. There is a note. That note is unpaid. I admitted it because it's true. We stipulated to judgment because the amounts they're requesting are valid. There's a note. That note went unpaid. I can't lie and deny the claim. I can't fight the claim. It's a true and valid claim. If you read my answer to the intervening plaintiff's complaint, they have kind of a mix of causes of action in there. Every allegation in the intervener's complaint related to the $50,000 note, I have admitted. It's a $50,000 note from Ms. White that went unpaid. I have admitted all of those allegations in the answer to Ms. White. We are not trying to treat these creditors differently. We have notes we want to pay. And again, I take offense to the allegation that I'm making a misrepresentation to the court. So I want to make my representation crystal clear. When I say there's no evidence of this case that an investment has been made into Teebs LLC, what I am saying is there's no receipt. Show me the receipt. There's certainly a lot of talk. As Mr. Furtado pointed out, Troy McLaughlin testified that it was his opinion that more money had been invested. Gail White says in her affidavit and in her complaint that she thought more was invested. I'm not saying nobody is saying that. I am saying there's no evidence in front of the court of a receipt that shows that payment. That is, I want to make it crystal clear. I'm not saying there's no evidence in the sense of people are saying things. People are certainly saying things. I am saying I have not seen a note that says here's a $150,000 investment into Teebs LLC signed by Gail White and Teebs LLC. I'm saying I see no records of payments made to Teebs LLC on behalf of Ms. White, other than those that are reflected on the $50,000 note. Now, again, I am not trying to do an end run summary judgment motion here. I am trying to say that there is an unpaid $50,000 note that's owed to Gail White. I'm asking the court permission to pay that note. It's a debt owed by Teebs LLC. I'm asking permission to pay it. There is a note in the Jeff Adair matter that is unpaid. I'm asking the court's permission to pay that. These are
the amount owed to Jeff Adair of $146,410, that there is an order and judgment in the other file for that amount.
correct. And again, Your Honor, the idea that my stipulation to that is somehow collusive is just simply not true. It's an unpaid note. That's the interest calculations. That's the amount owed. So what I'm attempting to suggest, Your Honor, I am not trying to treat any creditor unfairly. I am trying to pay the two notes that I know of in full.
There's not an order in that other file though for payment to White.
Correct, Your Honor.
Okay.
There's no order. What I am saying, Your Honor, is in Teebs's perspective, there's two promissory notes that are invested into Teebs. There's Jeff Adair's $100,000 note, which Jeff Adair has sued on in the other matter, that has turned into a judgment. There's a $50,000 note owed to Ms. White that, again, same thing. We defaulted. This is my interest calculation. If Mr. Troika thinks the interest calculation is incorrect, I'm happy to talk about if he thinks my math is wrong. This is simply my calculation of the interest, and the difference of treatment, again, is based off how the compounding interest works. And again, based upon how the timing of the investments. So if this is a math problem, I'm happy to work with Mr. Troika to resolve the math problem. As far as attorney fees of Miller Johnson, this is not a case where I have to prove the reasonableness of the fees to get another party to pay my fees. I'm requesting permission from my own client to pay my attorney fees. The client I am representing in this court, the client I have worked with, again, with my partner, Ryan McNally, to facilitate these sale transactions. We are requesting that our own client pay our attorney fees through the money that my client has. This is not a case where I need to go line by line justifying the validity of an attorney fee. This is a case where my client agrees these are fees owed, and I'm requesting that my client have permission to pay my own attorney fees. With that, unless the court has any questions, I'm happy to hear the court's ruling on this matter.
And Miss
Your
Judge,
Honor,
I think I've heard enough, so give me just a moment. All right, I appreciate your patience because I'm shuffling like all this paperwork and trying to keep track of all the gerbils in the cage. So, okay, so, all right, on file number, hold on, Becky, is Joanne in the courtroom?
Yes, she is.
Okay. Okay, I muted it earlier because Mr. Love was in the courtroom. So, all right, so in file number 23-237081 CB, that case is settled, but there are some remaining issues. So I am going to order, because there is a judgment in that file, I'm going to order that the escrow agent shall pay Jeff Adair $146,410 from the proceeds of the sale of the assets of Teebs LLC upon closing. I'm going to order that the escrow agent shall pay the state of Michigan $166,000 to, or $166,226 or any other amount stated by any Michigan taxing authority from the proceeds of the sale of assets of Teebs LLC upon closing. The escrow agent shall pay the appropriate taxing authority all outstanding employee and employer tax obligations. I am not going to order the escrow agent pay Gail White the amount of $68,333 from the proceeds of the sale of the assets of Teeb LLC upon closing. That issue will be reserved until the closing of this case. On file number 22, the completion of 22-226888 CB. I am not going to order attorney fees to Miller Johnson either at this point. And those will be reserved obviously until the completion of this case. I am, let's see, because attorney fees were already ordered in the Adair case, and that amount has not yet been determined, and that issue remains under advisement. Once that amount is determined, Ms. Subley can motion as intervener in this file 2022-226888 CB for release of those funds from the escrow. The motion should include whether the remaining funds from the sale of Barnstable Realty alone can fully cover the amount owed to her. And if not, why would she be entitled to funds from the sale of Teeb's assets when that company was not a party in the prior case? All right. All right. So with regard to, I'll go back to my notes. I'm sorry if my typing interfered. I do think, first of all, I don't think anybody's up to anything inappropriate in this file. All of the attorneys involved in this case are reputable. I've had you appear in front of me for many years now, and probably you are all some of the most ethical attorneys I've dealt with. So Mr. Troika made a valid suggestion about discovery is still open. There are some documents that the parties agree need to be exchanged. Mr. Troika suggested perhaps extending discovery for the purposes of Ms. Subley being able to get the documents she needs and Mr. Troika getting the documents. Oh, I'm sorry. Let me back up. Hold on a second. When I misspoke when I said earlier that Teebs was a party in the prior case, and I think the attorney fees typed out in. Hold on one second. All right, so I just clarify, so the motion that so Miss Subley can motion as an intervener in this file for release of funds from escrow. And she does not have to address why she would be entitled to funds from the sale at Teeps because it was part of, I misspoke on that, I'm sorry. Okay, so Mr. Trike had requested that perhaps it would be reasonable in this case to extend discovery for the purpose of Ms. Subley getting the documentation she needs upon request, and Mr. Trike any documentation he requests. Yes or no? An objection to that, Ms. Subley? Yes or no?
Yes, I don't need the documents from White if we can get them from the bank. That's what I was trying to say at the end of my remarks. So if you will order them produced from the bank, I don't need them from Ms. White.
Mr. Trike?
Well, Your Honor, I mean, how's that going to work? They're going to have to come from Ms. White. So I would like discovery extended, and I do want documents from Mr. Adair because I just heard references to things that relate to his claims against a limited amount of money. So I think the simplest thing is do what should be done, have a limited extension on discovery, and Mr. Adair can make the request he wants. I can make the request I want.
So I'm
Your
gonna
Honor,
extend- oh, yep.
We opposed an extension of discovery. This case has been ongoing for a year and a
It's
half.
only for those two issues. Not
I-
overall.
Sure, I understand that. And Ms. Subley and Jeff Adair have known of this case for 6 months. They could have intervened to request these documents long ago. They did not. This case needs to get to a point where we can have some determinations. It has been a year and a half. The sale has been pushed. It is apparently pending. Closing docs. We object
Well,
to an further discovery.
Okay, I appreciate that. My order will allow the sale closing to go. The money's gonna go to escrow. I don't see any reason why on the sole issue of the documents being requested by Mr. Troika and Ms. Subley, that discovery can be extended for 60 days to get that documentation.
Yeah, and I have one more question of absolutely, grave importance to my client. I did reach out to Mr. Carlton and I said, you need to stipulate to judgment for Ms. White, just like you did for Mr. Adair. And I sent that proposed judgment, did not hear back. With what Your Honor just said, I have some concern that my client won't get paid on an admitted debt and that all this money is going to disappear. So Adair gets 100 cents on the dollar and my client takes a discount. So I want to be able, first of all, I want Mr. Carlton to confirm they're not objecting to my client's claim under the $50,000 note. I will work with him to show why the real amount is $73,205 because it is, but I mean, we can work it out. But I want to be able to submit to Your Honor a consent judgment so that Ms. White gets the same treatment, that she gets the 73 or 68, whichever it is, from escrow, because otherwise this money's all going to be dissipated and this will be, she won't even get that, which is agreed to. So I strongly ask that the court allow that to proceed so that we are treated the same as Mr. Adair and are getting paid 100 cents on the dollar like he is. And there's no reason for Teeves not to stipulate to that. They did it for Adair. They're not objecting to our $50,000 note. So we should be treated the same. And I've made that request already.
Mr.
Your
Carlton?
Honor. Sorry, go ahead, Jacob.
Sorry, did the court have a question for me? Sorry.
I'm sorry, did you say you sent it to Mr. Carlton?
Yes, I sent him the proposed judgment on October 2nd. He hasn't said yes or no, but based on what he said to Your Honor and what he has said to me in many conversations, there is no objection to Ms. White getting paid on her note. If the court is not going to delay these payments based on insolvency, and if Mr. Adair is getting 100 cents, then I want to have my consent judgment entered and have the same treatment. I think it would be a gross miscarriage of justice to make her sit around and wait on an undisputed debt when there's insufficient funds to pay everybody.
Your
So we-
Honor, on behalf
So,
of Plaintiff McLaughlin, we have to object to this requested relief for the same reason we objected to an issuance of payment for Jeff Adair, that these are creditor payments that are not allowed under the escrow order. with respect to Mr. Troika's request that Gail White now obtain a consent judgment after previously arguing that the company is insolvent and those judgments should be equitably reduced, is absolutely inappropriate. Two wrongs do not make a right in this case for the creditors. What is going to happen is preferred creditors are going to get paid out, and there is going to be nothing left for frontline employees, employment wage, anything. That's what they are trying to attempt. They want to take all the money on a preferred basis and leave nothing from the sale for anyone else. This is inappropriate. It was the purpose of the escrow order.
So Your Honor has already ruled, as I understand it, that Mr. Dare gets preferential treatment, and there's absolutely no reason on God's green acre why Ms. White would not be treated the same. And as I understood it, Mr. Carlton doesn't object. So while I understand Mr. Furtado's concern, your court has indicated that Mr. Adair would get 100 cents despite the insolvency of the company. So Ms. White should as well. It would be just a gross miscarriage of justice to say that she, who has an identical note executed on the same date, the only difference being one says 100 and the other says 50, and I've made the request for a consent judgment, no reason for there to be any different treatment. And so we want to, I'm assuming Mr. Carlton will consent, submit it, and get the same treatment.
Your Honor, if I may briefly.
Yes.
Sorry that there's more and more brief comments here.
Yes.
Mr. Troika did submit that proposed consent judgment. I did review it. My intention, Your Honor, was that this motion would take care of the need to enter that consent judgment. I am happy to revisit the issue of the consent judgment with Mr. Troika. I'm happy to sit down with him and make sure the interest calculations are correct. And again, I'm happy if an appropriate, if we can agree on appropriate language of consent judgment like we did in the Adair matter, I'm happy to entertain that with Mr. Troika.
And Your Honor, we want it paid the same as Mr. Adair. That's the issue.
Your Honor, also, just to remind you, that is one of the reasons that I did such a long exhibit to the stipulated judgment for damages, because I believe we also acknowledged in that stipulated judgment, did we not, Jacob, that Ms. Adair's or Ms. White's promissory note was for $50,000. Neither I nor my client nor Jacob, nor I assume his client, would want to represent otherwise.
Yeah, so Your Honor, it is agreed. We had asked that it be paid in the same manner as Mr. Adair's.
All right. Okay, so I'm going to order that the meeting regarding this consent judgment happen within 7 days. And if judgment is entered from Ms. White, then those funds can be paid from escrow for only that
The
$50,000. Yep.
Understood. Thank you, Your Honor.
All right. And then I am going to, like I said, I'm going to extend discovery for 60 days for you to get the documentation and exchange it that Ms. Subley was asking for, and any that you might need Mr. Troika only relating to that issue. I'm not extending discovery for anything else. Okay.
Thank you, Your Honor. And one of us will be assigned the task of submitting an order. I hope it's not me, but I thought we should figure that out.
May I ask for clarification too, Your Honor? Would we be able to submit an order directly to the bank for the documentation that the bank has?
So, Mr. Troika, go ahead, Mr. Troika.
I'll say, if she wants to subpoena the bank, I'm not going to object. Obviously, any personal information like social security numbers needs to be redacted. But I don't object to subpoena going to the bank. Obviously, I'd want a copy of whatever she receives. I think there's a decent chance Ms. White actually doesn't have everything the bank has. So I think that would be the appropriate mechanism. And we're not going to object to that. Again, we just want to treat it with confidence.
And that's why I want it coupled with an order
Ms.
so that
Subley, you can do that.
that's
order
why I
then.
would like it coupled with an order and not just a subpoena. because that will be helpful, and we will arrange. What I was proposing was that we would.
Well, hold
give
on,
Mr.
Mr. Troika, you agree to all that?
Well, I want him to have an opportunity to redact. And so we submit it, to redact any personal information that needs to be redacted. But we have the account number, he can get it. We can get it from the bank with the amount and the date and the name of the account holder. We will not need to have any other of that sensitive information, but if it should come with that, he should have the opportunity first to be able to remove it. And then we submit it the same way under seal so that it's protected, so that Ms. White's protected.
Yeah.
Just the same way we protected Mr. Adair.
I don't think we're disagreeing. I think the appropriate mechanism is a subpoena. If the court were to enter an order binding a bank today, there's a decent chance the bank would have an issue because it's not here to defend itself. I'm okay if even the sensitive information goes to Ms. Subley, so long as we agree it's treated with confidence and redacted or filed under seal. The only thing at issue here, I believe, is going to be a social security number. And I don't like account numbers being in the court record, but we're not going to have a disagreement on that. My suggestion is that there be a subpoena issued. I mean, I'm not going to object that the court wants to put it into an order here. I just, that's going to come across funky, I think, to the bank, but whatever. I'm okay with those documents being provided as long as I get a copy and as long as Ms. White's confidences are protected.
And as I've said before,
So
the
Ms.
bank will
Subley,
honor an order.
Ms. Subley, can you prepare the order then, Ms. Subley?
Yes.
All right, very good. Okay. All right, so that motion's done. You guys agreed on the 7-day. What do we have remaining?
Just
Your
my
Honor.
identity as a permissive intervener as opposed to consolidation. I still would like the case to remain separate. I have some hope that we'll be able to conclude the other one without having to wait to 2025.
All right, Mr. Troika, you had mentioned consolidation.
Yeah, so Your Honor, I don't see how this works. This means things will be happening under a different case number at hearings where I'm not present, have no right to be there. Mr. Furtado has no right to be there. And then when it's done, Ms. Subley is going to come back to this case and say, I have a fait accompli that the court has to honor, which is actually, what just happened in the last week. We think it has to be in this case because this is an insolvent company and we're going to be fighting over a limited amount of money. So if there's, let's say Ms. Subley convinces, Your Honor, that she's put 20 grand in attorney's fees into this case, which I'm not saying she has, I'd want the ability to tell the court what I've put in. And if we ought to take a discount, it needs to be equitable, and we shouldn't have a situation where some claims are being determined in a separate proceeding, without the knowledge of others. And I do want to say, if we are going to keep it that way, then I will expect to do the same in this proceeding and I'll try to get rulings from Your Honor that are favorable to Ms. White, unfavorable to Mr. Adair. And when Ms. Subley shows up to object, I'm going to say, tough, you didn't consolidate, so it's binding. I don't think it's how it should be. But if your court keeps these as separate proceedings under separate case numbers, then there's going to be sort of a race to the courthouse element to this, which is just not efficient. If this was a solvent company, I would say differently, but we all know we're fighting over a limited pot of money. As a result of Your Honor's ruling today, we already know mathematically that now Teebs will not have sufficient funds to pay rent to Barnstable Realty. So there's already that. And that's setting aside Ms. White's additional claim and Troy McLaughlin's claim. So it's incredibly inefficient. I say they should be consolidated for all purposes. We can say, well, yes, there won't need to be a trial, I don't think, on anything, really, tell you the truth. So that's my wish. I think it's efficient. Would ask that the court order that.
Your Honor, just on behalf of plaintiff, I just want to say the case should have been consolidated. Either Mr. Adair should have intervened in this case, or when it was filed in June, he should have consolidated his case, or the court should have consolidated. Then it should be consolidated now. We're in this procedural muck and nightmare because these cases have not been adjudicated together.
And if I may respond, Mr. Adair already saw the muck had occurred through settlement discussions and realized that there was going to be a war among attorneys. So his.
So we filed a separate lawsuit
So,
after.
all
next
right,
week.
so what I will say is I agree with Mr. Furtado that these cases should have been consolidated a long time ago, but they weren't. So, we have a closed case on, T on, file number 23-237081, CB is closed now. So, I'm not gonna,
Your Honor, if I may ask. you-
Closed only as to count 1 and 2.
Right, so the
We
case.
still have counts 3 and 4, which we are hopeful will just result in the.
so does anybody
payments over
object to
time.
consolidating the cases?
No, this is still an open case with undecided counts, so it should
Would
be.
count, okay, so
It's just the counts on net
my question
proceeds.
was, are there any objections to consolidating by anybody?
Yes, I still object to consolidating the case because we're only dealing with the net proceeds issues of 20% and 20%. Simple math in our case, a huge fight over whether there's equity, et cetera, or Mr. Barnstable has committed fraud in the other case. We don't want to be exposed to any attorney's fees for that fight created by perhaps Mr. Barnstable or some combination of players in this rather acrimonious pitched battle in this case, in the 22-6888 case.
So if
That's
Your
our
Honor-
concern.
And my concern is that Your Honor will enter relief in this other case where I'm not present to defend Ms. White. And then it will be presented in this case, which is what just happened. And that doesn't allow us to express our position and defend our rights. And again, there's a limited pot of money. So I want to say, by the way, I share Ms. Subley's concern. I am stuck in the case. I intervened. I thought that was the right thing to do. This is where the money is. This is where the escrow order is. But I don't want to be in this fight between Troy McLaughlin and Steve Barnstable any more than Ms. Subley does. But I don't see how these can be done in separate proceedings because you're going to get inconsistent results.
And I'm certainly willing to cooperate, Mr. Troika and Mr. Furtado, with presenting you with anything informally for information purposes.
Well, I am going to then allow the cases to be consolidated. All right.
Thank you, Your Honor.
Okay.
And who gets to do that order? I guess,
I will do it as part of the other order.
all right.
Thank you.
Anything else?
I have a question, Your Honor. It has nothing to do with the relief. It has nothing to do with the motions. It's just something that Attorney Subley commented. She made a reference to a June 2010 deposition
Oh,
with
I'm
a
sorry.
ledger.
I meant June 10 to 2022, Mr. Furtado.
Who's that?
That's where the ledger and these documents had been.
Whose deposition was June 10, 2022?
Is it June 10 or
2020.
June 7?
She's referencing Barnstable's deposition. Will
That's right. And it was an
Okay.
exhibit.
23. It was the Barnstable deposition in our case.
And it was in,
correct.
I believe, August or July. Is that right? That's why I was very confused. We're referencing
No,
the
it's
June
in
2000.
June.
I think it was June 7th.
Yeah, I think it was.
Maybe it was.
I have it at June 7th. Yeah, and Jake,
I do
Okay.
too.
Ms. Subley referenced the ledger. Do you know what she's talking
Yes.
about?
It's part of the Excel spreadsheets that you
Oh.
received at that time. The ledger is part of that.
Oh,
You
okay.
received those documents then, not
Um,
just learning for the first time that there was a capital contribution. If you looked all the way through to the end, you would have seen both at the beginning, the convertible promissory notes in the amount, and at the end, under capital contributions, you would have seen, if you'd looked, the Barnstable Realty 190 and then the transfer of 10,000 to make it 200,000 for Gale. That's why I'm saying it wasn't a drive-by motion. You had it then.
Your
Right.
Honor, I was just trying to get clarity on the deposition that was.
That's
referenced more
fine.
than
And Ms.
15 years
Subley,
ago.
the order for consolidation will be based on the reasons Mr. Troika identified on the record. That's all the language. you need.
Okay.
All right.
Thank you.
Anything else?
Well, Your Honor, you said you had all day, so
I do. So do you guys want
Some other
to
thing.
like go into a breakout room? Do you want to mediate? I'm here all day.
Is defendant going to produce a closing statement for this sale, which has been requested numerous times regarding the funds that are supposed to be paid out of escrow for this sale that we've never seen?
When closing will occur, I mean, we'll produce it before. I mean, the problem we have is we have a lot of questions like this. Can we pay taxes? Can we pay excess taxes? Can we pay employee taxes? Can we pay employer taxes? It's impossible to generate a closing statement until we know some of the things today about what we can and what we cannot pay.
You can produce an estimate of what you need to pay at closing to finalize this sale. And that's what we've been requesting for months. Say we have to pay. We have to pay rent. We have employment wages to pay. We have whatever. Give us a list of those obligations so we know. We've been asking for months for them.
So that, I mean, the problem is this court's order. We have to figure out what we're allowed to pay. So today we found out that we can pay $166,000 in sales and excise taxes as part of closing. So how, I mean, you tell me, how am I supposed to generate a closing statement when I don't know what I'm allowed to pay at closing? This is why we filed this motion today, to determine what we can put in such a closing statement. So the answer to your question is $166,226 in sales and excise taxes, $62,308 in Barnstable Realty, $146,000 to Jeff Adair, and whatever amount we can stipulate with Mr. Troika.
And how much does Stephen Barnstable on his apparent note, how much in rents that are unpaid, how much employee wage claims? I mean, those are all facts that you should know going into the sale.
Well, according to the court's order, we can't pay any of those. So they're not,
I'm not asking you to pay. I'm asking you to let us know what they are so we know how much money is available to pay everybody else.
Well, it doesn't sound like there's enough money to pay everybody, but we'll figure that out later. So, Mr. Carlton, as that information becomes available on those numbers for closing, make sure you provide it to all the parties. All right.
And Your Honor, one last question. I'm wondering, are we entering the ISO in this case, which was a request of mine, so that the parties they have had it as an exhibit. So are we entering it so that these parties have the stipulated judgments and that exhibit that I mentioned that recites facts? Because we also asked for sales for closing documents as well.
No, I'm not going to grant that request.
Thank you,
Okay,
Anna.
so it is not being entered in this case.
No.
Okay, just want to be sure.
And
I'll add that to the order.
to Mr. Carlton and Ms. Subley, I'm going to shoot you an email. I don't know what you were talking about, Ms. Subley. I believe you in terms of this ledger. And so I would just ask, I'd like to get that informally because
I'll email it to you. I'll email it to you.
Okay, please do. Thank you very much, John. I appreciate your patience. I know this is a lot of fuss.
Everybody
all
have a good day. Thank you.
Thank you.